Welcome to the National American Indian Court Judges Association's Tribal Legal Advocacy Training Webinar, Tribal Law and Order Act Overview. The National American Indian Court Judges Association, NAICJA, is a national nonprofit membership organization devoted to supporting and strengthening tribal justice systems through education, information sharing, and advocacy. NAICJA provides broad and comprehensive training and technical assistance to support tribal justice system capacity building and partners with national organizations to educate the broader legal community and public about tribal courts and judges, and builds relationships between tribal and state court judges. NAICJA is the Tribal Justice Training and Technical Assistance Provider under the Bureau of Justice Assistance, BJA, Tribal Civil and Criminal Legal Assistance, TLOA program, offering training and technical assistance to TLOA grantees and subgrantees legal aid organizations. NAICJA's TLOA program seeks to increase and improve access to legal assistance in Indian country by providing training and technical assistance for the development and enhancement of tribal justice systems. Further, TLOA will assist in strengthening the capacity and the quality of indigent criminal defense services and defense strategies for tribal justice systems. NAICJA is coordinating and implementing a multi-part training series, including webinars, interactive virtual training modules, and podcasts covering the basics of trial court advocacy. The training series is tailored for entry-level legal services attorneys, either just starting out or those looking to bolster their tribal advocacy skills. At the end of this webinar, we will provide information on how to access the rest of the Tribal Court Advocacy Training Series. In developing the Tribal Legal Advocacy Series, we partnered with the Center of Indigenous Research and Justice located in Olympia, Washington. Our presenter today is Ron Whitener, the president of CIRJ. CIRJ provides public defense services to tribes in Western Washington and training support to tribal public defenders nationwide. Before founding CIRJ, Ron previously was the founder and director of the Tribal Court Public Defense Clinic at the University of Washington Law School, and he continues to serve as an affiliate professor at UW. In 2011, Ron was named a Champion of Change by President Barack Obama for his work supporting and encouraging public defense in tribal courts. Ron was appointed the Chief Judge for the Tulalip tribes for 4 years and also for the Tulalip tribes for 6 years. Ron retired from the Tulalip bench in 2020 and currently consults with tribes across the United States on tribal justice system development through the Whitener Group, a consulting company Ron formed with his brother and niece in 2009. Ron is a member of the Squaxin Island Tribe of Washington State and continues to be active in his tribal community through commercial treaty fishing and serving on tribal committees and commissions. In today's webinar, Tribal Law and Order Act Overview, we will give an overview of what the TLOA is, its history, and the case law that has shaped TLOA into what it is today. Thank you, Ron, for joining us today.
Thank you for having me. All right, so we're going to go over the Tribal Law and Order Act, a little bit of some of the things that it incorporates and some of the things that may have been forgotten by a lot of people. It's getting a little bit more mature. It was passed in 2010, and we've seen a lot of change in certain areas that TLOA covers. In other places, we haven't seen a lot of movement, but it's still a very important congressional act that shapes predominantly criminal issues at tribes, but can also go into a few other areas. So we're going to talk about some of those areas. So the goal of the Tribal Law and Order Act when it was passed, one was to increase and improve coordination. The criminal jurisdiction especially is a mess in Indian country. If anybody's taken any Indian law class or gone to a training, you've heard it described, as confusing, a patchwork of jurisdictions. But basically what you've got is tribal jurisdiction, state jurisdiction if you're in a public law 280, state, federal jurisdiction if you're in a non-public law 280 state. It's just a mess. And even in a public law 280 state, sometimes you have both state jurisdiction, tribal jurisdiction, or federal jurisdiction and tribal jurisdiction, depending on where an incident occurred. And because of the complexity of this, one of the goals of the Tribal Law and Order Act was to increase and improve coordination between tribal and federal jurisdictions who have concurrent jurisdiction over a lot of issues. It also was designed to try to be an act that didn't abrogate tribal sovereignty, but supported tribal governance and jurisdiction. One of its big goals was to reduce the prevalence of violent crime in Indian country. We are, unfortunately, the reservations and tribal communities have some terrible statistics and disparities in violent crime, especially in sexual assault and drugs and domestic violence. Those are three areas that TLOA really specifically targeted. It also was designed to try to provide more resources to reduce substance abuse in Indian country, and then to support collection and sharing of crime data among jurisdictions. Because with these three jurisdictions that are all exercising criminal jurisdiction in Indian country, it's difficult. There's no way to go to one source to be able to get all of the data regarding crime in Indian country in this country. So on the goal of increasing coordination between federal and tribal law enforcement, one of the things that the TLOA did was it created the Office of Justice Services in the Bureau of Indian Affairs. It took over the Division of Law Enforcement Services. The Bureau of Indian Affairs provides a lot of funding and also direct service of law enforcement in Indian country. Some places the law enforcement on a reservation is done entirely by Bureau of Indian Affairs law enforcement for most part. So it tries to coordinate the federal and tribal law enforcement efforts through this office. It also provides assistance and training to tribes in accessing and using the National Criminal Information Center, the NCIC database, something that tribes had not easily accessed prior to TLOA. It collects information on Indian country crimes annually. It tries to pull in all of the different data sources and provide one spot that you can see the statistics. And then it tries to document expenses and unmet staffing needs for tribal police and court staff. And it works with Congress to try to increase funding for those unmet needs. It also increased the coordination between Bureau of Indian Affairs and the U.S. Department of Justice. Excuse me. So it required a joint plan between US DOJ and the BIA on incarceration under crimes in Indian country. Remember, you've got the BIA doing law enforcement, but in a lot of tribal settings, the US attorney is prosecuting crimes in federal court under the Major Crimes Act or the Indian Country Crimes Act. And so this requires more coordination between US DOJ and BIA on incarceration. One of the things that also did is required that when a US attorney decides to terminate prosecution of a federal crime in Indian country, the US attorney needs to coordinate with the tribal law enforcement if the tribe wants to prosecute instead. When the US attorney declines to prosecute cases that it has jurisdiction over, one of the things that used to happen before TLOA is often the US attorney's office would just not prosecute something or dismiss something, and there wouldn't be any real information provided to the tribe about why the US attorney wasn't going forward. So now the US attorney has to submit prosecution declination reports to the Native American Issues Coordinator. The FBI is required to compile data on crimes in Indian country that's not referred for prosecution. So if for crimes that are investigated but not prosecuted, those data are supposed to be kept so that you can take a look at what is investigated compared to what's prosecuted to try to determine if there's some sort of problem because in investigation or why prosecutions are being declined at a different rate for Indian country than other places. And then the Attorney General has to submit this data to Congress annually to keep Congress updated on what's going on under the Tribal Law and Order Act. It also created a lot of tribal liaison positions. So if you have a U.S. Attorney Office that is located with Indian country within its region, the U.S. Attorney Office has to have a tribal liaison, someone who is dedicated to working with the tribes within the region of that U.S. Attorney's Office to coordinate prosecution between the tribe and the United States when you've got a crime that both jurisdictions have concurrent jurisdiction over, coordinating who is going to go forward with the prosecution. It works to develop relationships with tribal law enforcement to provide training to tribal law enforcement so that when the tribal law enforcement investigates crimes that occur on reservation that could end up in federal court, that the law enforcement at the reservation has enough training so that they won't do something that's going to damage the case in federal court. In that vein, it also specifically trains tribes on how to evidence gather to assist those federal prosecutions. TLOA set up a new thing called a Special Assistant U.S. Attorney, often referred to as a SAUSA. And basically what it is a tribal prosecutor who has the ability to be appointed to this special category of prosecutions in the U.S. Attorney's Office, who can then go up and either handle the prosecution of misdemeanors that are being prosecuted in federal court, or join with the other U.S. attorneys in the prosecution of a case that came out of the tribe and has gone into federal court. And then it creates the Native American Issues Coordinator as part of the Criminal Division of U.S. Department of Justice that coordinates and develops the application of federal statutes in Indian country. The next goal was supporting tribal self-governance and jurisdiction. So one of the things that this really addresses is the issue related to Public Law 280. For a reminder for people who don't know what Public Law 280 is, it was passed into the 1950s during what we often refer to as the assimilation era, when the United States policy was to try to assimilate Indian tribes into mainstream culture so that reservations could be terminated and we wouldn't need to deal with these sovereign tribes anymore. The idea was that tribes needed to get used to having the states have jurisdiction over them. And so what it did was it created mandatory states, or states that the act automatically gave criminal jurisdiction over the Indian reservations to the state: California, Minnesota, except for Red Lake Nation, Nebraska, Oregon, except for Warm Springs and the restored Cow Creek reservations, Wisconsin, except for Menominee Indian Reservation, and Alaska. And then if there was a state that wasn't one of those 6 states that had Indian country within it, it allowed those states to pass state legislation exerting Public Law 280 jurisdiction. And we call those the optional states, or the non-mandatory states. Not every state that has Indian country in it, though, passed legislation taking Public Law 280 jurisdiction, but many did. Washington State did, Idaho did. A lot of different states have passed Public Law 280, and it's kind of all over the board. They didn't just pass and took full criminal. Most of them took kind of, we're taking jurisdiction over these areas, and then you can opt in, and it gets to be a real jurisdictional mess. And I'm not going to go into all of the variations of Public Law 280. But what it also didn't do was it provided no financial or technical assistance to the states. So a lot of the states don't necessarily like having PL 280 jurisdiction. Some of them, they spend a lot of money on doing this that they don't get funding for. Sometimes you'll get situations to where the state doesn't prioritize the reservation much for law enforcement, and then you'll see high crime rates on that reservation, or the reservation is a long way away from other state law enforcement office hubs, and getting law enforcement to come to the reservation can be difficult. Public Law 280 created a lot of problems. So some of the PL 280 changes that Tribal Law and Order Act made was that first, the U.S. Attorney General granted authority to provide technical and other assistance to the PL 280 states. So the U.S. DOJ can now help the states deal with Public Law 280. One, the states need to have entered into cooperative agreements with tribes to investigate and prosecute crimes, with the goal to incentivize local law enforcement cooperation. And then tribes under state jurisdiction can request being placed back under federal jurisdiction. So the tribes can essentially ask for a retrocession from the state back to the United States. It also did more to empower tribal law enforcement. So it expanded resources and training to tribal law enforcement. It allowed the BIA and tribal officers to attend tribal and state police academies. It speeded up BIA tribal officer background checks, and allowed tribal law enforcement access to the NCIC database. That was actually a big one, because the NCIC database is where all criminal history is loaded to from all of the individual states and local jurisdictions. It also is where all of the protection orders are placed. It's where all of the warrants are registered. So it allows an officer, no matter where they are in the United States, to essentially see a very large amount of criminal information related to someone who could be residing across the country and just happens to be in their state. For years, tribes did not have access to the NCIC database. It also increased tribal law enforcement authority. So for instance, it amended the Controlled Substances Act to authorize tribal officers to arrest without warrant for any federal offenses committed in their presence. It also allows arrests without warrant for any felony. And then finally, it created the Indian Law Enforcement Foundation. I have no idea what the Indian Law Enforcement Foundation does. I have not heard of it since reading it in the Tribal Law and Order Act. So I don't know if it has any money. I don't know what it does, but it created it. Big part of what we see in TLOA is the enhanced sentencing. So it amended the Indian Civil Rights Act, which prior to the Tribal Law and Order Act, tribes could not prosecute anyone and put them in jail for more than a year and couldn't fine them for more than $5,000 per offense. We also saw a lot of kick around in the federal courts about whether or not a tribe could stack cases more than a year. So if a tribe was limited to a year, but they prosecute somebody and they are found guilty for a crime that has a year maximum, and then they're found guilty for a crime with another year maximum, could they order those to be served consecutively so that they actually serve 2 years under the old version of the Indian Civil Rights Act? And what we saw in the federal courts was sort of differences amongst the circuits on whether or not you could stack or whether it was just a year, no matter how many crimes the person committed and pled guilty to, you couldn't sentence them to more than a year. So that we had sort of this discrepancy in the circuits. So this made it clear that one, tribes could then expand its sentencing so it could put in place crimes with a maximum penalty up to 3 years per crime and a $15,000 fine per charge. It also allowed stacking of crimes consecutively up to 9 years. But it also required tribes to have increased defendant safeguards to be able to charge crimes with sentences that have a maximum over a year. So these due process safeguards, the biggest part really probably is they need to provide counsel. So effective assistance of counsel, so that you have to provide counsel that's effective, meaning that they're trained enough to be able to handle the kind of crime they're seeing. It has to be at the tribe's expense if the defendant is indigent. So essentially it requires a public defender. The defense counsel needs to be licensed in a jurisdiction with licensing standards that ensures competency and has rules of professional responsibility. The way the TLOA is written, a tribe could set up its own bar, require licensing, require competency and education and other things. As far as I know, no tribe has created a licensing system that conforms to this requirement. Excuse me. So in effect, what happens is that it requires that appointed counsel has to be a member of a state bar association. So they have to have gone to an accredited law school or gone through an apprenticeship program. Most people just go through law school because it's the shortest way. And then they have to pass the state bar exam. And then they have to maintain their whatever continuing legal education and maintain themselves in good standing with a state bar. And then they meet the definition for the Tribal Law and Order Act. It also requires that tribes have all their criminal laws, their rules of evidence and procedure to be publicly available. One of the problems that we often see with tribes is that it's difficult to access their law, especially before the World Wide Web and the internet. It was much more difficult to see tribes' laws. What this did was it requires tribes to make them publicly available. Now, what that means is up in the air a little bit. Does the tribe need to maintain a public law library that people can go to and pull hard statutes off? We don't have, we have some tribes who don't want to enhance sentences, and they also don't want to make their laws public. So they won't enhance sentences because they don't want to make their laws public. But what we're seeing more and more is tribes putting their statutes and rules of procedure and evidence onto their website. That is becoming more and more common. The presiding judge, and we have a webinar specifically that deals with the issues related to just judges and TLOA, but a presiding judge must have sufficient law training for a criminal proceeding. So they have to, the TLOA requires that if you're going to have a judge that sits on these cases where the maximum could go up to 3 years, or you want to stack cases beyond a year, up to 9 years, then your judge has to meet some sort of standard. Now, what that means is unclear. So sufficient law training isn't really defined. And you'd have to, argue it basically in your appellate cases to determine whether or not a judge isn't sufficiently law trained. Most tribes, though, if they're enhancing sentences or doing anything which requires this kind of standard, they're really erring on the side of having judges who have practiced criminal law or have had some sort of training in criminal law and are attorneys. So they are law trained and have some exposure and practice in criminal law. This way, the tribe doesn't expose itself to being overturned on appeal or having some sort of habeas petition going to federal court based on the Tribal Law and Order Act and this standard. The presiding judge must be licensed to practice law by any jurisdiction in the United States. And this is a strict standard. So this is why one of the things that's important is in state court, you don't necessarily have to be licensed to practice law. There's lots of examples of magistrates and other kinds of judges who do criminal cases that are trained that aren't required to be licensed to practice. In the TLOA, it does require that. So that's a stricter standard. So really what tribes are, again, as I'm saying, deferring to is having them be a member of a bar association. They need to be either active in a state bar or in judicial status. That's the safest. So another goal of the Tribal Law and Order Act, combating specific crimes of domestic violence and sexual assault. So the TLOA increased training opportunities for tribes on domestic and sexual violence crimes. It requires the Office of Justice Services and the BIA to train on how to interview victims. That was something that tribal law enforcement often had very little experience, is how to interview a victim of domestic violence or a victim of sexual violence. It provides training to tribal law enforcement on preserving evidence, and then training on how to present evidence to tribal and federal prosecutors, and to be able to present evidence in court at a trial. It also pushed for standardization of sexual assault policies. So one of the things TLOA required was Indian Health Service, which provides a lot of the health services for tribes, especially remote tribes in the lower 48, to develop standardized sexual assault policies and protocols. That's something that was all over the board prior to TLOA. And then it requires the Comptroller General to conduct a study of tribal health services facilities' ability to collect, maintain, and secure evidence of sexual assaults and DV incidents to make those crimes actually prosecutable. And then has to make a report to Congress with the results of study and recommendations. Another issue was the issue of subpoenas. Prior to Tribal Law and Order Act, federal employees didn't have to honor tribal court subpoenas to testify in sexual assault trials. So for instance, if you were on a reservation where your primary hospital and medical facility is an Indian Health Service facility, and you have a rape victim that goes in for an exam, the doctor who did the exam or the nurses who did the exam did not have to come to court if it was in tribal court to testify. They didn't have to honor those subpoenas, and often they wouldn't do it. And so you couldn't get medical records and you couldn't get people to testify in a lot of these cases, which then rendered, it made it very difficult for the tribe to be able to prove one of these cases at trial. So TLOA doesn't require their testimony, but the request can't, excuse me. The request can't be denied unless it violates the department's policy of impartiality. And if the department doesn't act, then it's deemed to be automatically approved if they don't act on it within 30 days. So it's not perfect. It doesn't automatically make them required to show under a subpoena, but it's a much greater improvement than what was before TLOA. So then another goal was the creation of the Indian Law and Order Commission to do an investigation and issue a report. So the Indian Law and Order Commission was created, and it was tasked with researching the jurisdiction over crimes committed in Indian country and the impact on investigation and prosecution. It was required to research tribal jails and federal prison systems' ability to reduce crime and rehabilitate offenders. It looks at the effect of tribal and federal juvenile justice systems and related programs' ability to reduce juvenile crime and rehabilitate youth. It looks at the impact of the Indian Civil Rights Act limits on tribal authority and fairness and effectiveness of tribal justice systems. And then studied other subjects and things that the Indian Law and Order Commission deemed relevant. So they did a report, an excellent report called A Roadmap for Making Native America Safer. They did over a year of investigations and listening sessions all around the United States. And they released that report to Congress and the President in November of 2013. They made a lot of recommendations, most of which have not been acted on. One was the ability for tribes to opt out of federal or state criminal jurisdiction, essentially being able to pull out of either the Indian Country Crimes Act, Major Crimes Act, or the PL 280. And have Congress recognize the tribe's ability to prosecute all persons on the reservation. So this was one that there has been some work on in terms of being able to opt out of Public Law 280. And the only thing about the tribe's ability to prosecute all persons, including non-Indians, the VAWA Special Domestic Violence Jurisdiction added the ability for a tribe to prosecute a non-Indian who commits crime of domestic violence on the reservation. I'm not going to go into the ins and outs of what the requirements of that are, but it's a small step in the right direction under the recommendation. They discussed establishing a special U.S. Court of Indian Appeals to hear appeals coming out of alleged violations of the Constitution by tribal courts. Congress has not done anything. I don't even think a bill has been drafted on this one. It allows opting out of, it argued for opting out of Indian Civil Rights Act sentencing limits. Again, there's been no congressional action. There was some very specific things to Alaska. Alaska is such a unique situation with the Alaska Native Claims Settlement Act that structured things in Alaska much differently, and the lack of Indian country in Alaska for the most part, other than a few examples. It argued that the Alaska Native Claims Settlement Act should be amended to allow lands held in fee by Native villages, Native allotments, and Native-owned town sites to be deemed Indian country. This is to address the Venati case from the United States Supreme Court, which found that lands that either used to be reservations or lands held by Alaska Native Claims Settlement Act corporations could be deemed Indian country. There was a fix for that, but Congress has not passed any legislation related to that. To allow lands held by NAICJA regional corporations to go back to Alaska tribes and be put into trust status. There hasn't been specifically language in Congress that did that. There has been changes to the BIA fee to trust regs that have allowed tribes in Alaska to put lands in trust, but this system to take corporate lands and turn them into trust status has not been acted on. One good thing that happened was it recommended the repeal of Section 910 of Title IX of the VAWA to permit Alaska tribes and villages to address deviant sexual assault under the VAWA. Originally, state of Alaska was able to get an exclusion for Alaska Native villages so that they couldn't take advantage of it. Excuse me. Congress did repeal that. It argued to affirm inherent criminal jurisdiction of Alaska tribes and villages over their members within the external boundaries of the village. Again, no congressional action on that. Now, this is unique to Alaska because without having any reservations in Alaska, what we see are Alaska Native villages who are essentially incorporated as townships or municipalities under state law. So they're governed under state law, but basically 95% of all of the residents are members of the village, the tribe, the federally recognized tribe. But because there's no trust land, things get very cloudy on jurisdiction on who they can prosecute and who they can't. Tribes in Alaska do have criminal authority. They have the ability to criminalize and prosecute their members that commit crimes, but they don't have the same type of jurisdiction to where, like we do in the lower 48, where if a member of a different tribe commits a crime on a different reservation, that tribe will have the ability to prosecute them. That is up in the air in Alaska. And so the goal of this is to create certainty here, but there hasn't been any action. In the area of law enforcement prosecution in the courts, it argued for creating a federal public defender system similar to SOUS's, where you would have more coordination between the federal public defender and tribal public defenders. Again, no action on that. Increase holding federal judicial proceedings in and near Indian country. So instead of having people who are being prosecuted in federal court going to a federal court a long way away, actually being able to convene federal court. In some areas of the United States, some of the states that don't have PL 280 jurisdiction, the federal court will prosecute fairly minor crimes often under the Indian Country Crimes Act. And the idea is to have those criminal actions actually be held on the reservation than have these smaller crimes being dealt with and people having to travel. I don't believe there's been any action on doing that. They argued to look at at maybe creating some sort of special federal magistrate judges who could go to the reservations to do these smaller criminal federal cases. That, as near as I can tell, has not been acted on. I don't know of any federal court district that has created any special magistrates tailored toward Indian country. They argued to eliminate the Office of Justice Services and BIA and consolidate it into DOJ. We do have a lot of, BIA usually on federal criminal stuff, that's almost all in United States Department of Justice. But we do have in BIA this Office of Justice Services that does law enforcement as well. And the Indian Law and Order Commission was arguing, rather than having two groups that are essentially doing very similar things, consolidate it all into US Department of Justice. That hasn't happened, and I don't think there has been much of a push for that to happen. And then create permanent recurring base funding for law enforcement and justice services for tribes, for all tribes, including Alaska, and that has not happened. Under detention and alternatives, they argued to require federal and state courts to inform tribes when a tribal citizen is convicted for a crime in Indian country and when they're slated to return to the community out of federal detention. There's not been any action on that. We have seen increasing reentry programs, though, and funding for reentry programs so that tribes can create things to where they keep track of people and provide services as they reenter. But it's not required for the federal and state courts to inform tribes when someone's convicted and when they're supposed to return to the tribe from either state or federal incarceration. They wanted to set aside a federal funding for jails in Indian country. No action. This is a little bit controversial because a lot of people don't want more jails. Excuse me. There's a lot of jails already in Indian country, and a lot of them are falling apart. And we don't have a lot of local treatment options. We don't have a lot of local sort of lesser incarceration methods, such as daytime reporting centers or things like that. So there's a lot of argument, instead of building more jails, to fund more of these things that will address problems that don't require you to send someone into jail. But this set aside has not been provided. And then the TLOA created a pilot project that allowed tribes to be able to petition to use the Federal Bureau of Prisons for long-term incarceration. So if someone's sentenced to, say, 3 years from a tribal court, this pilot program allowed the tribe to petition to have that person held in the Federal Bureau of Prisons. This was I don't think the Federal Bureau of Prisons, frankly, loved this idea. They created a system and they really narrowed what kind of crime they would take. And so very few cases actually use this pilot project. My opinion is that it was a good idea. We do have a lot of people that we sentence to, a year or more, and then they end up spending it in a local jail without a lot of services. That's really common. Or in a BIA jail, again, that doesn't have a lot of services. Whereas the federal system has educational opportunities, chemical dependency treatment, vocational opportunities, lots of things that they can do in those federal systems. So if you're going to send somebody to jail for 3 years, if you can send them to a lower security federal facility, they have access to a lot more things to be able to spend their time on. And in my opinion, they would come out less damaged than if you stuck them in a county, like rented jail for 3 years. But the pilot ended, and it has not been revitalized. Under juvenile justice, they wanted tribes to be able to opt out of federal or state juvenile justice jurisdiction. Again, no action. They wanted tribal consent prior to the federal U.S. attorneys being able to prosecute a juvenile that's a tribal member. That hasn't occurred. Congress hasn't done that. It wanted to require tribal consent to allow or disallow prosecutions as an adult. So having a juvenile being prosecuted as an adult and allowing the tribe would have to consent to that. There's been no action on that. And then one of the other last ones in juvenile justice, they wanted to amend the Indian Child Welfare Act so that when a state court initiates a juvenile delinquency proceeding of an Indian child for something that occurred off the reservation, that the state had to notify the tribe that they were prosecuting the juvenile. That also has been no action. So what we see is from TLOA, there's a lot of TLOA and the recommendations of the commission that have not really resulted in a lot of change, but there has been a lot of change, especially in the area of tribal law enforcement coordination and enhancing the ability of tribes to exercise its jurisdiction for more serious crimes. And that's the overview. Are there any questions?
Hi, Ron. I have one question. That was, you've said that no tribe had a licensing standard for defense attorneys, but have you heard of any tribes thinking about doing so? I know it would be a big undertaking, but it might solve some of their problems finding public defenders in rural areas who are, wanting to become tribal practitioner.
No, I haven't. Unfortunately, I mean, I think it's a good idea. There has been some discussion of like partnering with tribal colleges to create very specialized lay advocates who are trained to do criminal. I just don't think that it's come to fruition. Because I think just tribes are nervous, because if you have somebody and you're prosecuting them for a very serious crime, which probably is what it is if it's going to be one of these enhanced sentences, that's an obvious appeal point, right? If I'm the public defender and you give me somebody that's not a state bar licensed attorney, if I'm the lay spokesperson, I may note that, say, sort of arguing that I can't do it. And so I think it creates kind of a loop, and tribes are just nervous about it. So most tribes have just said, we're just going to use attorneys, practice, licensed by a state bar association. And so it just completely gets rid of that appeal issue. And plus the cost of creating a system is prohibitive. It's not something that a lot of tribes have the funding for. So the tribes that are way more rural, that they're having trouble getting attorneys, it's a little bit of a catch-22, is that they also don't have funding to be able to support like a whole new licensing system to duplicate what state bar associations do. So I think that's sort of the catch-22. Without funding for those, most of the tribes that really need them don't have funding in the first place to be able to support them.
Thank you. And then one other question was, there were quite a few no actions. Is there a no action that you would be most excited by actually being realized or coming to fruition?
I think the one that I always thought, maybe it's just because I'm a judge, but the TLOA has that throwaway section regarding U.S. magistrate judges. It doesn't have there's no meat on the bones. It just basically says the federal judiciary should explore the Magistrates Act, because the Magistrates Act allows the districts to create positions for magistrates, and the magistrates do a lot of the grunt work of the courts, hearing like motions or other things that are lower level, leaving the judges that are appointed by Congress or are confirmed by Congress to be really handling the more serious things. One of the things that we have, sometimes issue with is, these areas where the Indian Country Crimes Act applies, and you've got cases going into the federal system. A lot of the judges there, they're federal judges, and then they're hearing these small cases. People are having to travel long distances to go, to the nearest thing. If you're one of the tribes, say you're Pine Ridge, and then you have to go all the way into Rapid City for a federal prosecution of a minor crime, it's really inconvenient to everybody. Law enforcement that investigated everything. And so the idea of having sort of these magistrates who could go and sit at the tribes to hear these cases, I think would be really interesting, because it would be way more convenient for everybody at the tribe, including the defendant. And it would provide an opportunity for the tribal judiciary to sort of rub elbows with the federal judiciary, and an opportunity to learn more. And I think that would increase the capacity and skills of the tribal judges as well. So that one's always been, I don't know how much of an impact that would have, but I always like that one. In terms of the juvenile area, which is another area that's near and dear to my heart, a lot of those things are important. We have, especially in PL 280 jurisdictions, the states are often prosecuting a lot of juvenile justice cases. It's an area where you often see tribes not doing it. They'll do adult criminal, but they let the state handle the juvenile matters. Juvenile matters tend to be more expensive. Juvenile detention facilities are way more expensive than adult facilities because they have way more protections. And also there's a lot less juveniles in juvenile detention than there are adults in adult incarceration. So they just tend to be, naturally way more expensive. So a lot of tribes don't do that. And in PL 280 jurisdictions, they'll leave that to the states, but then we don't know anything about what the states are doing. So we do, I do a lot of court evaluations for tribes. I just did one for a tribe here in Washington, and they don't even know how many of their kids are in the state system. The state prosecutes all delinquencies that occur on the reservation, and the tribe doesn't have any way of really knowing how many or who is getting prosecuted or what the outcomes are from those prosecutions, because the local county doesn't have to report them. And so that's another area where I think TLOA would help. That would be near and dear, is if Congress could start making the states to be able to, if they're going to prosecute juveniles on the reservations, that they'd be able to provide to the tribes notice of that, and have some sort of information so the tribes can apply services. So that's one. Another one that I didn't address, though, is also the Federal Education Rights and Privacy Act. That wasn't in TLOA, though. That was in a different report, so I'm not going to talk about it now that I think about it.
Thank you, Ron. And I think that's all our questions.
Okay.
And I wanted to thank you, Ron, for presenting today. If you have any questions about this webinar, please email at info@NAICJA.org. You'll also find this webinar and the rest of the Tribal Legal Advocacy series through our website at NAICJA.org and through links shared on our social media, Facebook and Instagram. I want to thank everybody for joining us today.